About 2 years ago, we began negotiation with the Government of Canada and the Government of New Brunswick of what they called a framework agreement. That is, it's an agreement that sets the rules and the process and the content, the menu for the negotiations that we're having about land and rights and relationships between nations. It's taken us 2 years to negotiate that agreement. That's actually really fast. The Mi'kmaq Maliseet in New Brunswick and the Mi'kmaq in Nova Scotia took 10 years to negotiate agreements that frankly we don't consider to be nearly as good. We're not saying we're that much better. The Mi'kmaq and Maliseet were dealing with a federal conservative government that wasn't that interested in making agreements, and we had the advantage of being able to use their agreements to know what would work and what would help and where we would have trouble. This agreement is 16 pages long. It's 52 paragraphs long, double-spaced. It's dense in terms of what it contains, and we made a commitment to the people that what we do will be open and clear, and when the time comes for the people to make decisions, they will have an opportunity for what we call, and what the United Nations Declaration on the Rights of Indigenous Peoples calls, full, free, and informed consent. We're going to make sure that you have copies of this, but me sitting here in front of a video camera is part of providing that informed consent. I want to tell you what went into this agreement, what the thinking is, where the problems with it were for us, and how we got past those problems, because this is an agreement we can live with. We fought really hard to keep this agreement in plain English. If you read other agreements, they're full of Canadian lawyer language. We recognize that the people that we need to report to are people without law school educations. You'll notice that other agreements refer to Canadian court cases. We don't consider that this nation is under Canadian law. Canada is under Canadian law. New Brunswick is under Canadian law. They're welcome to refer to their court cases. They're bound by those. We're talking about a nation-to-nation relationship. And throughout this agreement, you will see reference not to one legal system, but to both legal systems as being equally respectable and equally relevant. Another thing about this agreement in comparison to others is that we are not afraid to begin to define and implement treaty rights. It's about time. These rights have been ignored for over a century. We know what they mean. We are not afraid to sit down and talk about that. Another thing, we're insisting on equal respect for the Besquet-Makati legal system. We call that a principle of reciprocity. You'll see on the very first page that the people signing this for the federal and provincial governments are cabinet ministers. They stand eye to eye with the chief and the council. These are real governments coming together. Another difference between this agreement and the agreements other people have made is this is a nation that's never been part of Canada's Indian Act, never been under the Indian Act, never elected its council pursuant to the Indian Act. And the other side of it is this is a nation that is one nation on both sides of a narrow river that puts part of its territory in Canada, part of its territory in the United States, but throughout these negotiations we've said this is one nation and all the citizens of the nation have equal rights. You'll see in the agreement that Canada is not at that point yet. You'll see in the agreement there are a number of things we haven't agreed on yet, but what we've done is we've said we've agreed to talk about these things and to work toward resolving them. Part of it says this isn't an agreement that we will agree, this is an agreement that we will negotiate toward an agreement. That is, this creates a process. It's a beginning in a lot of ways. It's a doorway. Now, the Government of Canada insisted that this agreement should not be legally binding because it's only procedural. And our reaction to that is, in that case, we don't need a referendum vote on a non-binding agreement. And that's a good thing because at this point in the rebuilding of the nation, we don't have a membership list. We don't have a voters list. We do know, more or less, who belongs, and we're reporting to those people and asking for their advice, their questions, and eventually their agreement. I'll run through this framework agreement as quickly as I can, pointing out, and the first thing I should point out is this 16 pages, this volume is all the drafts over the last 2 years. It took a lot of work. First paragraph talks about how for thousands of years the Besquet-Makati have been people of the lands and waters of Passamaquoddy Bay and its watershed. We would have thought that was obvious. The archaeologists say 11,000 years. Canada's reaction was, if you say you are the people of this place, then you may be claiming exclusive title. If you're claiming exclusive title, we would have to consult with the Maliseet and the Mi'kmaq about that. If we had to do that, there would be at least a 1-year delay. So we compromised. We know what the territory is. We know we can prove it. For the purpose of getting into the big negotiations, we agreed on compromise wording. Not that we are the people of the lands and waters, but that we are people of the lands and waters. I'm explaining that one in detail because this agreement is full of that kind of compromise. Another thing that you wouldn't think obvious, but that raised a debate that lasted hours, is saying, we're the people of these waters. And some lawyer in Ottawa, who remained nameless, said, we're not sure that Indigenous peoples can have rights to waters. Well, we never thought anything but. So issues like that are being postponed for later discussions. But every time a bump like that pops up in this agreement, we know it remains a flashing yellow light. The second paragraph acknowledges that to guide their existence in those lands and waters and foster peace and prosperity, the Crown's governments and the government of Besquet-Makati entered into formal treaties. We begin with the treaties. That's where the relationship is. We acknowledge that the British Crown entered into treaty relations with the other Wabanaki nations. That seems obvious, except the British Crown also entered into treaty relations with the Penobscot people, who now live in Maine and not in New Brunswick, and Canada fought to exclude them from being mentioned in this agreement. So what we're saying is true. Our truth goes beyond what the agreement says. Paragraph 4, the treaties are an intersection between the respective legal systems of the Besquet-Makati and the Crown. We're saying right up front, we have a legal system, it's respectable, it's real, it's going to govern how we behave. That doesn't show up in other people's agreements. It does, however, show up in the recommendations, the calls to action of the Truth and Reconciliation Commission of Canada. And the federal government is committed to that, and the New Brunswick government is sort of committed to that. They agreed to it in this agreement. Paragraph 5 says that we want to view the spirit, intent, and content of the treaties through the lens of both legal systems, but we acknowledge that our laws and our cultures and our languages have changed over time. We didn't fight over that. The Supreme Court of Canada said that Aboriginal rights and treaty rights aren't frozen in time, and they aren't frozen in technology. But it was only 20 years ago that the Government of Canada was arguing that the right to fish meant the right to fish with nets made of roots instead of nets made of nylon. Part of what's happened is that Canadian law and politics have evolved, and this agreement takes advantage of that. Paragraph 6, there are 3 communities of this nation: Skudik, Sibayak, Motokamikuk. At this point, at the time we finished negotiating, Canada was willing to acknowledge that from our perspective this is one nation, but it was only willing to negotiate with the people on the Canadian side. On May 2nd of this year, the Supreme Court of Canada made a decision in British Columbia that may have kicked that door open. We probably have to wait until after the next federal election to be sure what that means to the Government of Canada. From an introduction that talks about the treaties, we move to the principles that will govern us before we get into the details of the negotiations. The most fundamental one is that respect, trust, and friendship are the principles of the treaties. What we couldn't get Canada to admit to is that in 1766, the covenant chain relationship was extended to the 4 Wabanaki nations. And those principles are the essence of that relationship. So we got Canada to agree to the description without agreeing to the name. It's still important. Paragraph 7 also refers to implementing the spirit and intent of the treaties in a contemporary context as part of restoring a respectful nation-to-nation and government-to-government relationship. Those are high-sounding words. They're in fact lifted word for word from the Prime Minister Trudeau's mandate letters to cabinet ministers. Really hard for Canada to refuse them. Paragraph 8 points out that the treaties aren't just pieces of paper, that what constitutes the treaties and our understanding of the treaties is in writing and is in oral tradition and is in wampum, and all 3 are respectable evidence of what happened. It also talks about an enduring relationship rather than treaties as distinct events. Paragraph 9, we reaffirm the treaty relationship in 2016. Paragraph 10 says that the honor of the Crown and the honor of the Pescadmacati are fully engaged and bound up in the treaties, in our negotiations, and in this agreement. That's important because Canadian court cases say that the honor of the Crown is engaged. But we're saying that's only one side. Our honor is equally engaged, our honor is equally important, and equally to be respected. Paragraph 12 is a departure from Canadian comprehensive claim policy. There's recognition that there are Aboriginal rights and Aboriginal title without defining them. And then the agreement says this isn't about extinguishing rights. It's about implementing and clarifying and affirming them. This is modern Canadian policy, not even that of 10 years ago. And then paragraph 13 is the first one where the lawyers for Canada and New Brunswick brought in legalese. It says, this agreement isn't a commitment to reach agreement, nor does it prejudice, create, define, alter, affirm, or affect any right, nor does it affect any position of the partners. And we use partners rather than parties as a statement that we're in this together as friends. This agreement guides the partners to negotiate about matters and to seek to agree about them. Again, this is an agreement about a procedure we're going to use, not about the substance. Paragraph 14, this agreement doesn't affect anybody else's rights. That turns out to be really important. One of the things that's happening in northern British Columbia right now is an ongoing dispute between the Nisga's, who have an agreement with the Crown that seems to give them rights in territory that has traditionally been Gitanyaw territory. We're making sure that every agreement we make doesn't accidentally affect other people's rights. And paragraph 15 says the same thing. It says we will consult with the neighboring nations before we make decisions. Now, what it doesn't say is we have to get their agreement. It says we promise to consult with them, and to us, consultation means really sitting down and talking things over respectively in both directions. Paragraph 16 is the first time we use the word reconciliation. And when we use reconciliation, we don't mean it in the sense that the Truth and Reconciliation Commission of Canada did about residential schools. The residential school reconciliation is we did something terrible, even criminal. We've compensated victims. We're really sorry. We won't do it again. We apologize. Let's reconcile. That's not what we're talking about. What we're talking about in terms of reconciliation in Canadian law and in this agreement is how do we reconcile the fact that there are two nations, two sets of laws, two governments, and two ways of life in the same place, and they will continue to be. Paragraph 17. We have a commitment from two ministers of Indian Affairs that the people of Scoodic will be recognized as a band. The individual members will be recognized as Indians under Canada's laws. And we recognize that's important because it means people will be getting enhanced health care and education help and housing and economic development. But we also recognize in this agreement that the Indian Act is an obsolete federal colonial law and that we need to move past it so that the recognition we're talking about is important, but it's an interim step. Paragraph 18 basically says every negotiation is unique, and these negotiations will recognize the unique circumstances of our relationship, and Canada will not be bound by its existing policy on comprehensive claims. Turns out Canada hasn't been behaving as if it was bound by that policy anyway, because it wasn't working for the last few years. Paragraph 19. We may find we have differing views about the treaties. We'll work together to resolve those issues. We prefer negotiation to litigation. That's what Canadian courts have said, but it's important that we say it together. Paragraph 20, simply, we will conduct our negotiations respectfully, effectively, and expeditiously. It's not enforceable, but we've been waiting 20 years for these negotiations. Expeditiously means something. 21, we will not use any aspect of the negotiations against one another in any court because we're seeking to resolve difficult issues in good faith and with flexibility and imagination. It means we should all be able to be free in negotiations, to float ideas, to have frank discussions, and not be worried that somebody will be quoting what we said to a judge 2 weeks later. Paragraph 23, we make it clear that we're talking about territory within the geographic boundaries on land in New Brunswick and within Canada, where we're talking about ocean boundaries. Why is that important? Because we're not dealing with Canada and New Brunswick about Maine. We're not dealing with Canada and New Brunswick about land outside traditional Besqueto-Matadi territory. Paragraph 24 is the menu. It's what the negotiations will talk about. It's important to realize we don't even know what half these words mean yet. We will give them meaning when we negotiate about them. But it's a really broad menu. It's adopted from, we looked at 17 other comprehensive claim framework agreements and final agreements to draw up this list. And we also looked at New Zealand and Alaska and Hawaii and Australia. If you read through this, the negotiations will address everything from land and water and intergovernmental relations and governance and parks and protected areas. We also lifted entire paragraphs from the United Nations Declaration on the Rights of Indigenous Peoples. Again, hard for the Government of Canada, which has accepted and adopted that declaration, to refuse to put that language in this agreement. But essentially what we're talking about is an entire government-to-government, nation-to-nation relationship about how do we get along together once this is done. And yes, there's going to be Besqueto-Makati land and an economy and a government and laws and financial relations and relationships about all the things that the federal and provincial governments deal with. And yes, we lifted parts of Canada's Constitution to talk about dividing powers. 25, we understand each of these matters contains a broad range of topics. Any of us can raise those topics as well as any other matters required for us. So that list isn't comprehensive. We can add other ones. This is going to take long enough. It's like it's going to swim into focus as we move along. One thing that happened in 1937, the Government of Canada sold the Canuce Reserve. In 1944, it gave away the St. Croix Reserve. We've made a claim against Canada for having done that. Canada's agreed to negotiate. This agreement says every time we get together, until we resolve these two claims, we're going to set some time aside to deal with them. They're not big claims, they're important because they are Indian reserves. They're part of what makes Canada recognize this nation as what it calls Indians under its Indian Act. It's complicated. We don't expect the settlements to be huge in terms of land or money. We expect them to be important because they set principles. Paragraph 28. Some matters are more urgent than others. Some are simpler than others. Some we need to make agreements on right away because they are real issues right now. And so we made an agreement that some things will be interim agreements that we can negotiate quickly, and they'll remain in place until our final agreement. They include what I already mentioned about the Indian Act. We're going to be dealing with situations where New Brunswick or Canada are going to be developing or alienating land and resources. A good example is a pipeline. Another example is mining or fracking, which is coming. We may need to deal with these urgently. We've got the capability in these negotiations. Another one is fisheries. Fisheries are important partly because they are mostly federal, partly because the federal government has a policy in place to implement Indigenous commercial fisheries and is committed to dealing with us on that basis. Part of it is parks. We have a draft interim agreement with Parks Canada, but there are only 2 national historic sites in our territory. The important part of the draft agreement we have with Parks Canada is the extent of respect and cooperation that Parks Canada is willing to show and that we hope flows over into our dealings with other government departments. Another priority for us is identifying and protecting sacred sites and archaeological sites right now, not waiting for a final agreement. Paragraph 20 talks about the fact that in the treaty relationship, we have the right to raise concerns before they become disputes, and the Crown has to pay attention to that. It flows both ways. We're committed to that. Again, it was a situation where Canada is willing to agree to the fact of it without mentioning that it's part of the treaty relationship. We can live with that. Another thing we've done is we've said that the documents related to the negotiations will be confidential and will be kept that way in order to keep the negotiations freewheeling and functional. Again, if we were worried that anything we put in writing would appear in the newspaper the next week, we'd have very difficult negotiations. There's an exception to this. If the negotiations break down because somebody's acted in bad faith, everything they've done can be used in evidence in court as proof of that bad faith. The other thing is, even though the negotiations are confidential, even though what we're talking about is confidential, Canada and New Brunswick recognize that we have an obligation to inform the people, consult with them, and eventually secure their consent. So that's an exception to the confidentiality rule, and that's why I'm recording this right now. We decided not to keep detailed minutes of any negotiation session. We've seen situations where people fight over whether the minutes are accurate and spend time in each session on what do the minutes actually say. What we do instead is we keep track of commitments. At the end of every session, we write down what people promise to do, and right there, we initial it. It keeps the negotiations moving quickly. It keeps them simple. Paragraph 35, we'll try to have joint approaches to the media. We're not going to have a contest with Canada and New Brunswick over different versions of what's happening. Again, having joint statements both accentuates the fact that we're doing things together and prevents breakdowns. One of the first things we have to do, and by now I'm on paragraph 37, is agree on priorities. That is, what's the order in which we're going to negotiate the 30 things in paragraph 24. From our perspective, priorities include protecting land, setting apart land, setting up in fisheries, for example, environmental protection, followed by dealing with the health of the people, followed by real joint management of fisheries, followed by a sustainable food fishery, followed by, at the end, a sustainable, environmentally responsible commercial fishery. What we've been doing at the same time as negotiating this procedural agreement is laying out what our priorities are. So when we get into the substance, we're going to be ready, and we've already given Canada and New Brunswick examples of things that we want to do. What are the priorities? Some of them are the things that are easiest to agree on, because the more we can agree on up front, the more momentum, the more movement we have toward a final agreement. Some of them are what we call the rock-hard things that we will have to deal with. We may as well talk about the principles of them up front. Yes, there's going to be Besquet-Makati land. Yes, there's going to be Besquet-Makati water. Yes, some of it's going to be shared. Yes, we decide who the people are, and so on. They're going to be difficult questions. We're working internally, including consulting with the people, about what the answers are. we're going to have an annual work plan. That's partly important because the federal government, and to an extent the provincial government, fund the negotiations based on the work we say we're going to do. Meetings will take place in our territory unless we agree otherwise. That's really helpful to us because it means that the time the federal and provincial people take traveling, we spend that time preparing. It's helpful to us because when we meet in St. Stephen and they talk about how far and how distant and how complicated it is, that there's an international boundary, we can point right out the window 100 meters away and say, you mean 3 minutes walk from here? That's complicated. Meetings once every 6 weeks. That keeps the momentum going. It means that we have time to meet, to think about what happened, to meet with the people and report to them, to get some direction, to meet again on our side to prepare, and then to get back together. Once every 6 weeks is moving pretty quickly. Paragraph 41 talks about developing a 3-year work plan to make sure that we can have some financial stability. We're not going to attract permanent qualified staff if the most we can afford them is 1-year contracts. And as we develop, as we move along, we need to recognize that we're going to reach right across Canada to get the best and most experienced people we can. How do you terminate this agreement? 6 months notice. Fact is, if Canada and New Brunswick don't want to negotiate seriously, we may as well not have this agreement. Paragraph 44 says what we're aiming for is a final accord that we will propose to our governments. We may produce an agreement in principle as a preliminary step. We need to work out how do we approve, how do we ratify this. On our side, we need to figure out, are we going to have a vote? And who gets to vote? The accord, the final agreement, comes into effect when it's ratified. We need to figure out how. Final paragraphs. In Canadian law, you usually see something that says this agreement may be amended in the same manner it was made. We put in something that says the following principles of Beskodmokati law shall guide us with respect to amending this agreement. We're human beings. We all carry a legacy from our ancestors and obligations to our future generations. We do the best we can. We will make mistakes. When we do, we'll be forgiving toward one another, and we'll work together to make things right. That's part of what the old treaties say, and that's part of what the old people say. And it was interesting when we put this to Canada and New Brunswick that their negotiators understood and their lawyers had difficulty with the idea of accepting these ideas as being law. It was a lesson for them, and yeah, it's law, it's just not your law. Not all legal systems are the same. And they had to look at, well, are these things true? Are we human beings? Of course we are. When we said we have obligations to future generations, one of the questions is, oh yeah, how many? And what are those obligations? And we had to have the conversation about, we don't need to define that right now. We're talking about principles, not details. The last paragraph, I should say, we got to a point in the negotiations where I think it was New Brunswick negotiators said, well, how do we end an agreement like this? And yeah, it was me that said, well, why don't we just say, and in the end, the love you take is equal to the love you make. And they said, that's the Beatles. And we said, yeah, so? It took 8 months for the federal negotiators to say, we don't have Paul McCartney's permission to use his words. We don't think we can do this. And I produced my letter to Paul McCartney asking him for permission. And in the end, they said, we can't do this because our superiors in Ottawa might not take this seriously. We got to do something else. And that's where we ended up with a final paragraph that says, in all three languages. And French is important to us, partly because it's an official language of Canada, partly because it's an official language of New Brunswick, partly because Acadian people are really important allies of ours. They understand what it's like to be dispossessed. They understand what it's like to be treated like a marginalized minority. It says, we're all children of our mother, the earth. Our ancestors have ensured we could meet here in this moment together. Let us work together now to help take care of our mother, our ancestors, all of creation today, our children, and all of those who are to come together in the future. Let it be that way. That's old Besquet-Mukati thinking. It's also now Canada's thinking and New Brunswick's thinking. And part of what this agreement does is take several steps toward saying each of the three governments is moving in its own way toward common ground. We're not just doing something inside Canada's policies or New Brunswick's laws. We're creating something new and different together. So that's the framework agreement. That's where we are now. We're looking to have the agreement confirmed at community meetings, confirmed by the councils of the two other communities, signed this fall, and in place so substantive negotiations begin this fall.